Good evening, Chairman Craven, members of the committee. My name is Lynette Lavigne. I'm a volunteer attorney with the ACLU of Rhode Island. We've reached a critical juncture in our cultural and legal landscape. The status quo in which the right of reproductive choice is preserved by federal decisions starting with Roe v. Wade is about to unravel. To borrow from another cultural and legal phenomenon, time's up. If reproductive choice as we presently know it is to be preserved in Rhode Island, the General Assembly needs to act now and pass House Bill 5127, the Reproductive Health Care Act, which does simply that: codify the principles of Roe v. Wade and later decisions, and repeal unconstitutional provisions remaining on the Rhode Island statute books which conflict with those principles, and nothing more or less. I want to walk you through the provisions of H 5127 to show you how it does that, and nothing more or less. I will also address House Bill 5125, which does not achieve that goal. Section 1 of House Bill 5127 is the proactive section which recites the principles of reproductive choice that are established by Roe v. Wade and later cases, for which I will use the shorthand Roe principles. It is written in descriptive terms which set forth the Roe principles to prevent any claims of ambiguity or confusion about what is meant. And what is meant, as in the Roe principles, is that the decision whether or not to continue a pregnancy to term is declared by our state to rest in the individual pregnant person. It says that the state can never interfere with the individual's decision to carry a pregnancy to term if she so chooses, and that the state can interfere with the individual's decision to end the pregnancy after viability, except when that decision is necessary to preserve her life or health. Section 1 includes the definition of fetal viability described in Roe, and which the Supreme Court made clear is a medical determination in Planned Parenthood versus Danforth in 1976. Section 1 also makes clear that making the proactive Roe principles Rhode Island law will not alter or restrict the current laws in force in Rhode Island which concern or create limits on abortion, and which do so constitutionally and consistently with the Roe principles. Thus, Section 1 recites that the proactive provisions do not abrogate or negate state laws which are currently in force and conform to Roe principles as a matter of Rhode Island law. These restrictions that are kept in place require informed consent before the abortion is performed, require parental consent or a judicial determination before a minor's pregnancy can be terminated, preserve the right of medical participants to decline to participate in abortion or sterilization based on their religious or moral objections, require medical care to an infant born alive during an abortion, regulate fetal experimentation, and exclude abortions from state-funded family planning services. They would remain in operation just as they are operating now. The rest of H 5127 is devoted to clearing up the state law and law books to get rid of unconstitutional provisions that have either been struck down or never enforced, so that there is no ambiguity or confusion in passing a law preserving reproductive choice. Thus, Sections 2 through 6 repeal laws still on the books that have previously been declared unconstitutional, or in the case of the Quick Child statute, recognized as unconstitutional and unenforceable and never enforced. Section 7 revises the state law preserving the prohibition on state funding of abortions and health insurance provided to state employees, but removes 5 words which relate to municipal employees, and which was declared unconstitutional in 1986. Section 8, which preserves prohibition of state funding for abortions for Medicaid recipients, is revised to conform to federal requirements. For those of us who believe that the status quo does not go far enough in preserving and protecting reproductive choice, H 5127 does not go far enough. For those who believe that the status quo goes too far because it does not protect fetal life, H 5127 does nothing to roll that back. In short, H 5127 does nothing new in terms of the current state of reproductive choice. What it does do, if enacted, is preserve the current state of reproductive choice as a matter of Rhode Island law, so as to no longer be dependent upon principles of federal court decisions to provide such protections. Without its passage, reproductive choice in Rhode Island rests on the next decision of the U.S. Supreme Court. Truly, time's up. I would like to close my remarks by addressing H5125. It appears that the drafters of H5125 started with Section 1 of H5127 in modeling the proactive reproductive choice protections embodied in the Roe Principles. But peppered throughout H5125 are qualifiers and modifiers, which can only be understood to create ambiguity and uncertainty as to whether those provisions are real or can be undermined elsewhere in H5125 or other laws. Thus, the initial provision in 5127 designed to codify Roe is revised in 5125 to start with the qualifier, except where restricted by federal law. Well, what does that mean? Federal law, because of the supremacy clause of the U.S. Constitution, always trumps inconsistent state law, where the federal law has the right to legislate on a subject. That is why Roe principles provide reproductive choice protections right now, and not because of Rhode Island law. But what if Roe is overturned and federal law no longer protects reproductive choice? Does that constitute a federal law restriction within the meaning of 5125? You can bet that those opposed to any reproductive choice protections will argue that it does. And that is exactly what was meant by including that proviso, since otherwise it would have been superfluous, since the Supremacy Clause says that federal law always controls when it's on the subject. And our Rhode Island Supreme Court has many times cautioned that interpretations of state law should give meaning to every word appearing in the statute. If those words are truly unnecessary, and we believe they are if preserving reproductive choice is the goal, then it is dangerous to add them. This is also true of language in 5125 adding after the words evidence-based medically recognized standards, the qualifier that are in compliance with all applicable federal and state law. Evidence-based medicine refers to science, not law. The addition of those words is dangerous. They are not superfluous. They are designed to alter the meaning of the protections and transform them from ones based upon medicine to ones that permit the argument and meddling by the state or by state bureaucrats. 5125 also does not preserve the current status of reproductive choice in Rhode Island. In addition to those qualifiers, it fails to repeal the state's partial birth abortion statute, which was declared unconstitutional in 1999 and affirmed on appeal in 2001 after the U.S. Supreme Court ruled a substantially identical law unconstitutional. Leaving it on the books, especially while reciting that evidence-based methods of abortion may be restricted by applicable state law, leaves a wide-open loophole in a post-Roe world that the most common form of pre-viability second trimester abortion, which is called dilation and evacuation, or D&E, not the so-called partial birth abortion method, could be viewed as outlawed or non-compliant. If the goal is to preserve the current state of reproductive rights and not increase or diminish them, then 5125 fails to do that by failing to repeal the state's unconstitutional partial birth abortion statute. 5125 also does not repeal the unconstitutional and never enforced quick child statute, but instead proposes to add a new criminal prohibition against fetal homicide. It contains a definition of quick child, which seems similar to the definition of viability, but is not the same and therefore creates instant ambiguity and confusion by having two competing definitions in the same bill. It also has nothing to do with preserving reproductive choice and should not be tacked onto a bill to preserve those rights. It contains no protections for the pregnant person or medical personnel who, with her consent, are performing a termination, leaving the possibility that the quick child provision would be used as a backdoor way to restrict reproductive choice, to intimidate women, or criminalize their behavior during pregnancy, or to create a status for a fetus as a person. 5127, in contrast, repeals the original provision, quick child provision, in its entirety. In drafting H5127, the RHCA, the sponsors followed a path designed carefully to lead to a restriction of provisions to create a state law which makes the principles of Roe a matter of law in Rhode Island, no more and no less. H 5125 veers off that path and thus does not fully reach that destination. I look forward to the committee's favorable consideration of 5127, and I would be pleased to answer any questions that you may have.
Any questions? Yes, Blake.
Thank you, Chairman, and thank you, Counsel. I kind of want to focus on the quick child portion of 5127 because I'm concerned that we're eliminating the crime for fetal homicide by a third party. Is that the intent? Is that what we're doing here?
The quick child statute, which was adopted, and I think it was 1975, if you read the full language of it, it makes expressly clear that it covers abortion procedures, criminalizes those, and has no exception for the life or health of the mother. And because that's in there in a criminal statute, it was recognized as unconstitutional right from the beginning. It was not struck down because the doctors who challenged it were found not to have standing because they didn't perform procedures after 20 weeks. So it's still technically on the books, but it's never been enforced. That's the only provision that I'm aware of that says anything on the issue. It's ineffective. It's never been enforced.
But if there were to be fetal homicide, someone could still be charged under the statute because it's, as applied, it's not unconstitutional.
Well, I don't practice criminal law, so
But
but what I'm going to say is that, as I understand it, in the criminal law, these are called penal statutes, and they have to be narrowly construed. And if it's unconstitutional on its face, then it's not going to be enforced against anyone, even including the kind of circumstance that you're talking about.
So this hasn't been ruled unconstitutional at this point, this statute.
No, it was recognized as unconstitutional and therefore never enforced.
But as it applies to a willful abortion, it was found unconstitutional.
No, it wasn't. It has not been declared unconstitutional at all.
At all. So right
Correct.
now, if someone were to commit fetal homicide on a third person, they could be charged with manslaughter under the quick child statute.
You're going to have to ask one of the attorney generals for the last, I think it's about 45 years, who's never brought such a prosecution as to whether they think that this law has any enforceability. As my understanding, it's never been enforced because of those fatal flaws.
So let me ask you a question. Is it your position that we should be eliminating a manslaughter charge on a third party that, without the consent of the mother, kills the fetus?
It's our position that the quick child statute, which purports to make it a crime to perform an abortion at any stage after quick child, how that's defined, except with just the exception of life, not health, is unconstitutional, and leaving it on the books as written contravenes the current state of the law and preserving reproductive choice.
So then should we be reforming it to cut out reproductive choice and actually leaving it intact for fetal homicide? I'm trying to understand what the position is here. Should we be disallowing fetal homicide?
It has no place, as it currently is written, it interferes with reproductive choice.
But we're talking about a third party
But
who's taking away someone's reproductive
But
choice.
we're talking about forming legislation that preserves reproductive choice.
So you wouldn't have an objection if we reformed it to take out the abortion provisions, but kept in fetal homicide?
It has no place in a statute that's designed to preserve reproductive choice. It also, the way it's written in 5125 raises questions of criminalizing behavior of physicians and the pregnant woman or person.
Let's cut out physicians. Let's cut out the pregnant woman. Let's say there is a third party who slips a pill in a pregnant woman's cup and causes her to have an unwanted abortion. Should that person be charged with manslaughter or a simple felonious assault? And a felonious assault, the maximum penalty is 6 years in prison. For manslaughter, it's 30. Should we only be going after that person for felonious assault?
I am aware of other states that have adopted a variety of protections, either enhanced sentences, it's kind of like, I'm making the analogy, no one, giving an enhanced sentence for a hate crime or when some catastrophic result occurs. All those things are really relegated to as the General Assembly, your decision-making, but it really has no place in legislation that's designed to protect reproductive choice. And putting it there creates the danger of elevating fetal status to a person equivalent to the pregnant person, and it just doesn't belong here. That other issue, talking about whether or not there should be either an enhanced sentence or some other protection in those kinds of catastrophes, and whether it should be criminalized, are really important issues, but they really have no place in a bill that's designed explicitly to preserve reproductive choice protections in a post-Roe world. And I'm not saying that it's not something that you should be confronting, but not here.
Well, I think we do need to confront it, and just so I understand your position, the enhanced penalty crime would be for what, just under your perspective, for what the bad actor did to the mother, not what the bad actor did to the fetus.
There are states that have passed those. I mean, this is not something I've studied. My focus is reproductive choice for the pregnant person, and this has no place there, and as the law is on the books, interferes with reproductive choice.
Thank you. And we cannot get rid of our fetal homicide statute, Mr. Chairman. Thank you. We can change it, but we cannot get rid of fetal homicide.
Dr. Kavesi.
So, as a layman, listening to a very interesting legal discussion between two very learned lawyers, as a layman, I would assume that the distillation of the problem is you don't want it in there because it elevates the fetus to the status of a human being.
A person within the protection, the same level of protection as the pregnant person.
So they would be equal.
Yeah, that's the concern. That's part of the concern.
Okay. Basically, therefore, you would be elevating the fetus to personhood.
That is certainly what people advocate who try to get those things passed, and
And
that
that's why you
stands in-
feel, and that's why you feel it's not appropriate to be placed in here.
Well, it's more than that. If you look at the first part of either 5127 or 5125, Section 1 explicitly says that the state shall, and I'm doing this from memory, that the state shall enact no restrictions that interfere with the pregnant person's ability to terminate the pregnancy at any stage, and post-viability, they can be protected except they cannot interfere when the termination is necessary to preserve the life or health of the woman. And that puts the life or health of the woman as or person as the primary inquiry. And that is what Section 1 says. If you were to say no, that the fetus has an equal status with the life or health of the pregnant person, then you can't make those decisions. And
I would agree with Leader Filippi 110%. Thank you.